All right, so we're up to about 70 people in the room. Today, I'm pretty excited. Lee Maddox has decided to come on and help out. He definitely jumped at the opportunity to talk to you guys. He understands there's a lot of anxiety and apprehension during these times with the COVID-19 crisis. I asked Lee if he could present, and he had a topic that he has a lot of his clients calling him on. I'm going to let Lee do his own bio and introduction. Lee and I have had the pleasure of presenting together before, but today I'm going to sit back and enjoy the presentation with you guys and partake in the information that Lee has for us. So we've got about 100 people in the room. At this point, Lee, I'm going to go ahead and throw it over to you. Just a quick note to you guys, if you have questions, there is a Q&A box that you can pop up. You can put your questions in the Q&A. Towards the end of the presentation, Lee's going to tackle as many of those as we can. Yesterday, we had close to 100 questions. We got through most every single question that came through, but please put the questions in the Q&A box. There's also a chat panel. If you can't hear us, or the audio's off, or something's going on, feel free to put it in the chat panel, and we'll go ahead and address that and see what we can do to figure it out. 100 people in the room right now. Bring up your Q&A box, put the questions there. Lee Maddox, take it away, my friend.
Good morning. Thanks for joining us this morning. I hope everyone can hear me well. This is my first Zoom experience, so if we have any technical difficulties, I apologize. We had the IT guy working with us, so we should be okay. So this is a topic that has been going on now for the last, I'd say, 4 weeks. Back in March 15th, I remember on a Sunday having conversations with lots of my colleagues, the other lawyers and accountants, about the impending shutdown or the recommendation that was coming from CDA. And CD came out on the 16th of March, and my phone started ringing, and the first question of the day was, do I have to pay my rent? So the lease issues are being asked and answered by both landlords and tenant attorneys across the board. I represent probably 70% tenants and 30% landlords, so I have a view of both sides, and I'm going to try to give you my perspective on it today. A lot of what I'm going to present can be kind of legal heavy, and it's not that you need to digest all that. It's just so you have an understanding when you talk to your attorney regarding these issues, what's going on in the back of their head. And it's actually very interesting for all the attorneys that are doing this. We're having to really go back to law school, first semester, to discuss contract law, to really get an idea of really what's going on in this space, because a lease is a contract, and we're going to go over that. So let me just talk to you about who I am. Every once in a while I have to look to the left to get the other screen, but there we go. So I went to USC undergrad. I was a bio major. I went to USC Dental School in 1987. I went to USC Endo School, finished in 1989. I was an associate while I was in endo practice. I came out and purchased a practice in 1989. I started becoming disabled by 1992. Hired an associate, ended up selling half my practice by 1992, opened up a de novo, a brand new location in 1993. And 1994, I had hand surgery. During that time, I got my board certification. I had shoulder surgery in 1995. I built out another office in 1996, had a second shoulder surgery in 1996, and retired from dentistry at 35 years old in August of 1996. After that, I took an ownership interest in a company with a dental manufacturer named Timecom Dental. We made nickel titanium rotary files, and we did a lot of amazing things there. We made the head of the handpiece smaller. We made the breakage go up from 2 millimeters to 16 millimeters, got into tapered file system, reduced the files from 16 files to 4. It was or 5. Really kind of an amazing experience to see the other side of the business. We sold the business. I went back to law school from 1997 to year 2000. Did some criminal defense work, and I did some patent work. I did all noble pharma patents. And then I started becoming, I entered into the transactional law field in 2001. I started working for Barry Josselson, who's in the city of Orange, and we did all healthcare transaction law, and that's currently what I do today. In 2010, I decided I wanted to be a practice broker, so I opened Maddox Practice Group, and we were working primarily in Southern California. My first agent was Kerry McCullough. And we did pretty well. We got bought out by Henry Schein in 2013. And after that, I became the western half of the United States for Henry Schein, or I like to say the western half of the United States, 7 states. And I retired from the brokerage business in 2018 and returned to the full-time practice of law in 2018. So I'm very happy to be back in the law space full-time. Married 30 years, 4 children, 30 to 24, 2 girls, 2 boys, 3 cats, and 1 dog. So that's me, and here's what we're going to talk about today. So I'm always trying to give people perspective, whether I'm talking about transactional events where buyers or sellers are coming together, or shareholder situations in corporations, or we're talking about setting up some kind of a partnership relationship. It's good to try to understand the other side. And so today we're going to talk about landlords and tenants, and it's a symbiotic relationship. Everybody needs each other. Everybody's in this game together at this point. And it's supposed to be a mutual relationship, but I know when I'm on the tenant side, it feels a lot like it's an unbalanced relationship. And it feels like that because landlords sometimes, they kind of bully us around, and landlords have 100,000 square foot space, and we're trying to rent 12, 14, 1,500 square foot, and they act like we're not important. But I think today they realize how important we are. I mean, in large spaces, we pay the bills. They may have a few big box tenants, but a lot of those big box tenants are not paying their rent right now. A lot of the big box tenants have gone out of business. And so the smaller tenants are certainly important, but it does feel like an unbalanced relationship. And that's what we really try to do as tenant counsel. No matter who you're working with, we're trying to balance the leases out so we have a fair shake in the lease. But unfortunately, it feels like an unbalanced relationship when landlords are doing well. And it feels like an unbalanced relationship when landlords are doing poorly. When they're doing well, they don't tend to give much, and when they're doing poorly, they cry poor and they say they can't do too much. So from a tenant's perspective, it always feels like it's rough. It's an uphill battle, and I get that. And what we try to do, and I know all my colleagues try to do, is try to create a balanced relationship. But it does feel a little bit like this, where we're helping the landlords, but the landlords, we always feel like they want to attack us and eat us and take all our money. So unfortunately, that doesn't change in today's environment. And so we're going to just jump right in here to what a contract is. So a contract is a promissory agreement between two or more persons. It creates or modifies or destroys a legal relationship, and it requires mutual assent of the parties to do something or not to do something. So the important thing of the last 2 points is all contracts are different. We have a freedom in contracts to make different provisions and to come up with their own terms that we want in the contract, and landlords do as well. And that is really important here, because the leases are all different. It's like all crowns are not the same. One crown doesn't fit all. One lease isn't the same, and the terms we're going to go through may be different in every single lease that we have, because we do have this freedom to contract, and we do have the freedom to create whatever it is that we want at the time that we're negotiating our contract. And we're obviously more successful if we have leverage, and we're less successful if we don't have leverage. And that's that's the relationship of negotiations. So a lease is a contract. It's a contract by which one party conveys land, property, services to another for a specified time, and usually in turn for some kind of a payment. So we pay rent, we get to occupy the space, and the landlord in turn has to do something for us. They have to give us quiet enjoyment. So that means we have to have, peacefully, reasonably, without disturbances, be able to occupy our space. And that's an important issue today, because if the landlords were not to provide us with quiet enjoyment, if they weren't opening up the buildings, if they weren't keeping the common areas open, if they weren't providing the same services that they were before, the landlord would technically be in breach of his lease, because he's not providing the quiet enjoyment that we expect, or that we contracted for in our lease agreement. So that's basically what a lease is. This is what's going on, as you guys are very much aware. Almost all dental practices are closed. It all started happening on March 11th when the World Health Organization said there was a pandemic. We all know what that means. And then March 16th, the day the CDA came out and said they strongly recommended that dentists only perform essential services and not perform non-essential services. That's the day my phone started ringing, because everybody wanted to understand what their liability was. And I think we've all seen that there's at least one lawsuit going now, or where Walmart's being sued for a wrongful death because one of the employees there happened to die from COVID-19, and the patient and the attorney are claiming that they didn't take the necessary steps to protect us. So I thought it was an unfortunate move that the CDA came out with this guidance. I thought it really put us in a bind, because it made us choose between opening our practices and closing our practices, and having potential liability if we do open it, both from patients and from our employees. A series of counties then came out and issued shelter-in-place orders. So wherever you are in the country, you can take a look online and find out when and if you've been sheltered in place. But certainly in California, we've been heavily impacted by this. And to the point, on March 19th, our governor came out and set up a shelter-in-place order for the entire state, and said that he recommended non-urgent or non-emergency care be initiated. And so that became the law of the land in California. And I'd say if you were open between March 11th and March 19th, by probably March 19th, your practice was at that point pretty much shut down. April 1, 88 came out and backed the same position, saying that all dentists should keep their office closed, but everything but emergency care. And April 7th, we had the California Department of Public Health coming out again with the same idea. We have to postpone all non-emergency care, all the routine care needed to be canceled. So no hygiene services, no band changes in ortho, no trade switch out in Invisalign. And then in April 8th, the CDC came out and essentially did the same thing. So the effect of all of this has been, all of our practices closed down, and it's very frustrating. I shouldn't say I'm not a dentist, so I'm not an actively working dentist, so I'm not practicing dentist, but essentially all my dental clients and friends are having their practices closed. So, first question everybody wants to know is, do I have to pay rent? And technically the answer is yes. You're in a contract, that's a binding contract. The landlord has expectations. The expectation is you're going to pay a certain amount of rent over a certain period of time. Whether it's a 5-year lease, 7-year lease, or 10-year lease, you're going to have to pay that rent until the end of the lease term. And again, the landlords have to provide you with quiet enjoyment and whatever else is required in the lease. If you don't pay your rent, then the landlord can technically charge you a late fee, and most of the landlords have the right to charge you 5 or 6%, or some up to like 10% of the late fee plus some reasonable interest rate. And there was also a default section a large default section in most leases, where the landlords have the right to put you in default, and they would have to actually give you a 3-day written notice. Most leases will say the landlord has to give you a 3-day written notice, and if they give you a 3-day written notice and you don't pay your rent, then the landlord would have the right to terminate your lease. So I want to just let you know that there's no statutory language that is out there in California, and I'm pretty certain the rest of the states, that say automatically if there's a pandemic, you don't have to pay your rent. So the default position is you have to pay your rent. The question is, can I get an excuse to pay my rent? And that's really what we're going to go over today. So how can I avoid paying rent? So if you want to try to figure out how to avoid paying rent or trying to get some kind of deferment of rent, we really need to look at the specific terms of the contracts and really dive into your lease and figure out, is there something textually in what is written in the contracts that's going to offer us a defense or an excuse not to have to pay rent? Or is there some other law issue that's going to allow us to not be able to pay rent? So maybe some common law terms like impossibility, impracticability, or frustration of purpose. These aren't things that we typically are talking about when we're talking about office leases, but there may be something that we can use in trying to negotiate some kind of a middle ground position with the landlords. Okay. So one of the things you're probably hearing a lot about is a force majeure clause. So a force majeure clause or an act of God clause is something that's in many leases. It's not in AIR leases, if you have one of those, maybe not in the CAR leases, but if you have a custom drafted lease, it's probably in there. It's a term, it's a provision that's typically in the back of the leases. It's typically not heavily negotiated unless you're from a state that has a lot of hurricanes or a lot of flooding. Certainly in California, we have earthquakes, but they come so infrequently. We don't see a lot of negotiation on force majeure clauses, because obviously landlords do not want to draft any provision in the lease that makes it so you don't have to pay rent. So basically, what a force majeure clause is, the Black Legal Law Dictionary definition says it's meant to protect the parties in the event that a contract cannot be performed due to causes which are outside of the control of the parties. And I think certainly COVID-19 should be considered outside of the control of the parties, and could be avoided by exercise of due care. And there's no exercise of due care that would prevent that. So an alternative definition is superior forces beyond the control of any of the parties to the contract. And we're using this as a defense of breach of contract where performance is rendered impracticable or even impossible by a force majeure event. So if you're having a conversation with the landlord, your conversation with the landlord is, I don't want to have to pay rent because there's a force majeure event, a pandemic. It's beyond my control. There's nothing I can do about it. It's not allowing me to practice dentistry. And that's what a force majeure clause is. There's a test in California, and it says there was such an insuperable interference, so insurmountable interference occurring without the party's intervention as could have been prevented by exercise of prudence, diligence, and care. So again, it's just when these cases come to court, if they come to court a lot of time when we have UCC cases where somebody's supplying goods or services. But here we're renting an office space, but still we're being interfered with because of something that we can't control. And so I think we could pass the test. So who does the clause protect? So a force majeure clause can protect both the landlord and the tenant from performing their duties under a contract. And that's very important to remember. We're trying to use the force majeure clause to not have to pay rent. Landlords may use force majeure clauses against us to get away with things in the contract, like maybe getting away with saying that the landlord has the right to rent their space to a dentist, even though you have an exclusive right to rent to a dentist. So we have to be very careful before going out and requesting from landlords that they don't pay rent because we want to exercise the force majeure clause. We really want to make sure there's nothing in the lease that's so unique and so important to us that we want the landlord to be able to use it back against us. And that's an important thing to keep in the back of the mind. Not something to super stress out about, but it is something to give some consideration to. So which obligations does the clause excuse? Well, it depends on what's written in the clause, depends on local laws and the connection between the pandemic and how you're affected. So if we have very broad language in the contract, that broad language tends to make it gives a wider chance of having us be able to enforce a force majeure clause. And specific language, very narrowly tailored language, where they specifically lay out exactly what is going to be excused, that is going to be it's going to be interpreted by the court very narrowly, and we're going to have to rely on that in our argument against exercising our rights under the force majeure clause. So what are specific language? So if you look at your lease, you might say that you have to comply with some law or government order. Certainly what's happening with the shutdowns would apply. Any action taken by government and by these just a random selection from different leases. Any action taken by government or public authorities, including imposing embargoes, or some kind of restriction or prohibition from being able to occupy our premises. Delay by supplies, certainly not being able to get the N95 mask, I think applies. Material shortages, increased costs of obtaining workers, and maybe not even being able to obtain workers. Certainly some of our workers are not showing up or not wanting to show up, since articles have come out in the press saying how dangerous it is to be in a dental office. Certainly the USA Today article was damaging, and how aerosols are particularly problematic in the spread of the COVID-19. Of course, we're all aware of that, and universal precautions have been around a long time and worked very successful in our practices. An act of war, of embargo, industrial disturbances, court orders or laws, and disease or pandemic. So there may be somebody out there who has a lease that has disease or pandemic in the leases. I just don't see it very often, but certainly that could exist. But they also have some broad language, and broad force majeure language addresses an act or event or circumstances beyond the party's control. So I love when I see this language in the lease, because it's very broad, and an example of that is other causes beyond the reasonable control of the parties obligated to perform. So if I read a force majeure clause that says this, there's a pretty high certainty that the landlord is going to agree that we don't have to pay rent. The downside is sometimes if this were to go to court, a judge could find the language way too vague to enforce it. But most of these situations are not going to go to court. And so just in a communication with the landlord, if there's a force majeure clause and it has this very broad language, or going back, if it has a specific language that we can use, like, not being able to get supplies, or maybe we can't get our staff, but certainly the broad language helps us out to say to the landlord, hey, we can't perform our obligation under our contract because the government, the regulatory forces are saying we can't open our practices. And it's because of the global pandemic, as defined by the World Health Organization, I can't perform. And so the broad force majeure language would certainly help us. And the force majeure language will typically lay out, and I don't think I have this in my slides, but it will typically lay out what it will allow you to do. So when you read your force majeure language, you want to see, does it say that I don't have to perform under the contract for a certain period of time, or does it say that I have the right to terminate the lease? Most force majeure language out there just says that you don't have to perform so long as you're being interfered with because of the force majeure event. They don't typically have language in there that says that you get to terminate your lease, but certainly should be looked at. If there's a notice provision in your force majeure clause, it's very important that you pay attention to that. I've read hundreds and hundreds of leases. I don't remember reading very many, or if any, leases that said that I had to I had to notify landlord within a certain period of time. But if you happen to have that language in your force majeure clause, and it says you have to notify the landlord within 5 or 10 days of the event, that could be problematic because as we see, things started happening back in March 11th. They really got dicey starting March 16th, and then March 19th, when the state shut us down, that's when it became really, really real. So, you know, if there were to be a notice provision, the question is, at what point did we need to give that notice? And landlords can potentially use it as an excuse that we're not in compliance with the terms of the contract because we didn't comply with the notice provision. So when you have your leases reviewed, they're not only going to look at the notice language and how we would actually, you know, comply with the notice requirements, but we're also going to look and make sure there's no timing requirements in there when we have to give this force majeure notice. So how do the courts in California typically interpret force majeure? I mean, it's difficult. I can just say this in the start. It's the last bullet point there. To my knowledge, the courts have not ruled on whether a plague or an epidemic such as COVID-19 is a force majeure event. So there's nothing you can directly point at that says absolutely, you know, we have this event going on. The courts are going to come in and they're going to help us. But what courts tend to do is they construe force majeure language very narrowly. So they're going to look at the text of the contract and they're going to use that as their reference. So if you have very specific language, and in that very specific language it says one of the events there has occurred, then they're likely to accept that. If you have very specific language and it's not on that list, they're not very likely to do that. And then with the broad interpretation language, like I said, the courts can go both ways. They can look at it and say it's all encompassing, but they can also look at it and say it's too vague, and so we can have a problem there. But the California Supreme Court case, and it goes way back to 1946, said that the court should analyze whether an event made performance impossible on a case-by-case basis. So as I said before, one crown doesn't fit all, one force majeure clause doesn't fit all. Every situation is different. It would have to be looked at very, very carefully when the lease is analyzed. It'd be very, very carefully construed when it goes into the court system. So if an event is not something for which a party assumes any risk, a force majeure clause would probably excuse that party from the same performance. That comes from the same case. In the event it is not mentioned in the contract, but as a general risk of doing business, the performance is not excused. So, you know, if you were driving, you had a trucking company and there was a snowstorm, that would be part of the business. It doesn't have to be mentioned in the contract. It's not going to be excused because the truck couldn't make the delivery. An economic downturn alone is generally not going to be construed as a force majeure event. So an economic downturn resulting from a pandemic is going to help us. But if we just had an economic downturn and your force majeure event didn't tie to it, it really wouldn't help us. But here I think we can make the argument, but for the pandemic and but for COVID-19, our offices would be open because obviously the states and all the regulatory agencies wouldn't be shutting us down. So that's pretty much how the courts look at it. In my opinion, I think COVID-19 is a force majeure event. It doesn't matter what Lee Maddox thinks, but that's the position I take. And like I said, I represent both landlords and tenants. If I'm representing a landlord, there's a force majeure language in the lease, and it's broad or it's specific, and the specific issues are identified. I'm going to recommend to the landlord that we make some kind of concession to the tenant. If I'm representing the tenant, I'm going to write a landlord say we should take a look at this force majeure event, and the force majeure event that has occurred, I think should allow my tenant not to have to perform, and that means not have to pay rent for that period of time. So that's my opinion. If you called me on the phone, I would give you the same answer. This is sample force majeure language, and everything in it's good until we get to the yellow. And so this is unfortunately what happens. But if you look at this language, the things in here that help us out, it says that stoppage due to strikes, lockouts, labor disputes, acts of God, inability to obtain services, labor or materials, or reasonable substitutes thereof, or governmental action, civil commotion, goes on. These are going to be collectively called force majeure, and it shall excuse the performance of such party for a period equal to any such prevention, delay, or stoppage, and therefore if the lease specifies a time period performance or obligation of either party, that time period shall be extended by the period of delay. So this is a really nice force majeure language because it's saying if any of these events occur, you're not going to have to do something in the lease, but we are going to add to the lease some additional time. Now, what's problematic is the last sentence: under no circumstance shall a party's inability to pay monetary obligations of that party be deemed to be a force majeure event. So a lot of landlords will take their force majeure language and then add in the language that says, yeah, but you can't not pay rent. So it's not going to be excused for paying rent. So that's potentially problematic, and it certainly can be argued in courts that it's an unconscionable term in the contract and it goes against public policy. But that's an argument that would happen by a litigator in a very contentious legal event, where the landlord's saying, you put in a force majeure language and then you forced us to eat this other language saying we don't have to pay rent. But I will tell you this, that landlords as a whole, if they put this language in, they're going to take the position that you have to pay your rent, that the force majeure clause will exclude other things, but it doesn't exclude you having to pay rent. And we'll talk about some of those things. So what are some other lease terms in a contract? And I'll talk about, for you people that don't have force majeure clause, I'm going to give you some other alternatives as we move on here in the slideshow, just stay patient. So what other terms in the lease could potentially help us? There could be something called abatement of rent clauses, meaning you don't have to pay rent. Abatement of rent clauses typically are tied to certain things happening, where the landlord hasn't performed, or the building is being repaired, or you don't have access to the building, or you don't have access to services. But it's possible, it's not entirely not possible, that your leases may have a clause in there that just says that if you can't use the space, you don't have to pay rent. So you may have this broadly written term in your lease, and if you certainly had that, and you can comb through your lease, do a word search for abatement, and if you had a clause in there that says if you can't utilize the premises, then obviously you would have an automatic event where the landlord would have to agree to some kind of a rent abatement period. Another term that helps us in the lease is quiet enjoyment. As I told you, peacefully and reasonably without disturbances, having the right to use our space. So the less services the landlord provides, the more our quiet enjoyment is interfered with. So if you're in a multi-story building and the landlord is shutting down access to the common area and access to the elevator, instead of being open from, say, 7 to 6 at night, it's now open, say, from 8 to 3. That certainly is interfering with your ability to utilize the space in the way that you intended to. And that we can make an argument not only in quiet enjoyment, but some other contract terms that will come up that we can't utilize our space. So not being able to use the building, the project, or the common area can help us. Now, landlords have terms that could hurt us. If you are in a retail setting lease, the landlord might have terms that say we have to continuously operate the lease. It has to be fully operational, so you have to be open and working. You have to be fully staffed. If you're not there, you're abandoning it. You're engaged in abandonment, and they can have the right to terminate the lease. Going back to our force majeure language, we could use our force majeure language here to say that, well, even though you say I still have to pay rent, the force majeure language is going to be a tool for me to say to the landlord, I don't have to be open continuously, I don't have to fully be operational, I don't have to fully staff. So the force majeure clause is going to help us to not be in default of other terms of the lease. So there's multiple ways you can be in default of the lease: by payment of rent, and other terms such as like this, being continuously open for business and operating with full staff. I did mention holdover clause here. A holdover clause is a clause in the lease that says that if your lease ends and you go on a month-to-month basis, the landlord has the right to charge you 1.5 or 2 times your rent, 150 to 200 times your rent. So for those of you that are on month-to-month leases, be very careful. This is a very difficult time for landlords. It's a very difficult time for tenants. And what's happening is, if you're a tenant, you're not really sure whether you should exercise or enter into a new lease with the landlord. And so you might want to just ride your lease on a month-to-month basis, but be aware that if your landlord has a holdover clause in your lease, and most of them do, some will say it'll be the same rent month to month, but most of them put in some kind of a penalty provision. So if you're riding on a month-to-month lease, be aware that the landlord could charge you 1.5 to 2 times your rent. So if you're going to stay on a month-to-month basis, and you're not quite ready to exercise or to move into a new lease, get some kind of commitment from the landlord that during that time, after the lease is ended, for a month-to-month basis, that they're not going to charge you this increased, punitive rent charge of 150 or 200% of your rent cost. Okay, so we do have another alternative out there, and this is the less talked about alternative, and this is called California Civil Code Section 1511-2. In California Civil Code Section 1511-2, I call it the default force majeure provision, and what it really says is the one of performance of an obligation or of an offer of performance in whole or in part or any delay therein is excused by the following clauses. And there really are three, and I've only addressed one here. Two have to do with creditor interference. But this says, when it is prevented or delayed by an irresistible superhuman cause, or by the act of public enemies of the state or the United States, unless the parties have expressly agreed to the contrary. So in my view, the Civil Code section makes it very clear that a court should not hold a party liable for a breach of contract when the performance was impossible because of causes beyond their control. So if you don't have a force majeure clause in your lease, that's okay. I would come back to the landlord and say, under California Civil Code section 1511(2), I have been prevented because of a superhuman cause, COVID-19, and I am unable to perform the terms of my contract because I cannot occupy my space. And when I send letters out to tenant letters, I'll typically address force majeure. If there's not a force majeure clause, then I will address California Civil Code section 1511 and really lean on it to say that this is our default force majeure provision. And I think that COVID-19 qualifies us not to have to pay rent or get some kind of rent deferral. So, so Civil Code section says that states that the Civil Code will not apply if the parties expressly agree that the event will not affect performance. So what that means is 1511.2 won't help us if we agree in advance that the problem that we're now experiencing was anticipated and we waived our rights to it. And I put an example there: rain will not delay playing of the football game. Or if we put in a contract that rain would delay a concert, well then obviously the rain delaying the concert would be there. If we didn't have in that contract about rain delaying the concert, we could potentially use 1511.2. But if we specifically write in there that rain won't delay it, then we're out of luck. So I've negotiated many office leases over the years. I can't ever remember writing in an office lease that an epidemic, a pandemic, a plague we'll just agree to keep operating our dental practices. So I can't imagine that any of us at our office leases have any kind of provision that have interfered with section 1511.2. We haven't pre-decided there was a problem related to a pandemic and said that we're okay with it. So that may happen in the future, but right now I don't think it happens. So that's so COVID. I think COVID-19 should be considered a superhuman cause. I think everybody would agree with that. It was not foreseen by the parties. It was not expressly agreed to by the parties, and I think it should excuse a performance. So if we move beyond the specific terms of the lease, the force majeure clauses, the abatement of rent, those types of situations, and we have COVID-19, there's some other contract provisions that we may potentially be able to lean on, far more difficult, far more esoteric, certainly something that would come up in a conversation when we're anticipating going into litigation. You might have heard the term that lawyers like to throw everything, the spaghetti against the wall and see what sticks. If you're going into litigation, you try everything you possibly can to get the result that you're looking for. And so the next 2 or 3 things we're going to talk about are things that we would throw in as defenses to try to excuse a breach of contract and try to get what we want, which is to get some kind of rent reduction or some kind of a deferment of payment. So impossibility means that there's literally no possible way for the party to perform its duties, and it excuses a party's performance when the subject matter or the means of performance, rendered performance, are objectively impossible. So it's a stretch. We can't operate our dental practices, so there's other ways that we can make the payment on the lease, but because we can't operate our dental practice, which is our primary way of earning income, I think it's something we could try to make the argument on. It would be a factual event that goes into the litigation that it could go either way. But essentially what it means is the performance of a contract is excused when there's an unforeseeable event, COVID-19, outside of the party's control that renders performance or impossibility, and that's a case. So California holds that the inability to perform must consist in nature of the thing to be done and not in the inability of the obligor to do it. And so I think the inability to get N95 masks due to disruption of the supply chain and other vendor shutdowns has contributed to our inability to perform in a safe way to do the nature of things being done. I mean, if you can't get N95 masks, you can't be doing dentistry. Well, that's a secondary issue to the fact that most of us are sheltered in place, and most of us are being told that if we go under our practice, we can't do anything other than essential dentistry. But I think a fallback position is, yeah, we can't do it because it's impossible, and we can't do it because it's possible. We can't even get the supplies we want. We can't get the staff in there. So if the only way to perform would be go to extreme hardship or expense, it's still possible. So here, there is no other way to do it. You can't, there's no substitute for N95 masks, although I do have some of my clients that are, they're sterilizing their masks, they're putting them, I don't know how they're doing it. They're putting 2 or 3 masks on top of their N95 masks. They have 1 mask for the day and 1 mask for the week. I mean, it's incredible that we have such a lack of supply in PPEs, but I don't think that this qualifies. I think extreme hardship I would say it's difficult to prove this. Typically with impossibility, we have to have a complete and permanent impossibility. And at some point, we're going to end this. I mean, I've been talking about maybe a June end date. I don't know if it's going to be July, but at some point, we're going to be able to go back to our offices and get back to work. So anyways, this may make it difficult, but certainly it'd be an argument that we'd make if we really got into a nasty dispute. And the courts may require that we do something to try to mitigate the risk. That's not really a big deal for my dental offices. Mitigate means to do something to minimize the risk. You have a dental practice, that's it. That's the only place you can work, so there's no way to mitigate it. I'm being a lawyer, I can work anywhere, so I can mitigate the risk by working at home or working anywhere, a library, where they're close to. So I don't think the mitigation to risk thing will hold us up. Other common law defenses, impracticability and frustration of purpose. So here, this is an occurrence or condition, like a pandemic resulting in a stay-at-home order, and the non-occurrence of which would be a basic assumption of the contract, which renders performance extremely expensive or difficult. The condition was unforeseeable, and the contract does not otherwise allocate risk for the occurrence, so it's starting to sound like what we talked about already. And the landlord must know that the tenant's sole purpose to lease the space was to operate a dental practice. So this is spelled out very clearly in your use provision of the lease. So if your lease says you can only do dentistry, or you can only do specialized dentistry, or if you can only do, dermatology or optometry, whatever your field is, the landlord would have a difficult argument to say that you can do other things to make your business work in that space. Unlike me, my office lease says it's for general business use, so not being able to practice as an attorney, while it'd be painful, I could still lease the space and do other things. But here, specifically for dentistry or optometry, vet, whatever you do, it'll help you. It doesn't help you if in the use provision it says you can use it for dental or any language or any other lawful purposes. So if we have to be careful with this, we have to read the language before we try to apply it. But if it just says dental and it doesn't say we can use it for any other lawful purpose, then we're okay. If it has any other lawful purpose, that could potentially defeat, our defense. So, so the contract obligations of contract interpretation, impossibility, frustration, purpose are all questions of law for the court to decide. So these are all things that will happen if we go to litigation. So your options are to go to litigation or get a go for a declaratory action. A declaratory action, you could go in and it short circuits the legal process. So you can go in and say, I'm being harmed, help me now, without going through the full litigation. So these are some options that are available to us. Obviously, the burden of proof is on the party bringing the declaratory relief action. This is a two-sided problem. So this is what I want to get to. Everybody needs to realize that each problem is being harmed. So landlords are being harmed, tenants are being harmed. The reality of the situation is most of my clients are not going to sue the landlords. So we are being restricted from our space for a short period of time. And as a result of that, the expense of the rent is not a very large amount. 2 or 3 months rent might equate to, anywhere from say $3,000 to, if you have a really big office, maybe $30,000, maybe $50,000, but it's not a huge number. And because it's not a huge number, it's unlikely we're going to litigate that number. Now, as time goes on, if you were to be out 6, 7, 8, 9, 10 months, everything changes. The whole presentation maybe changes because maybe some of these common law things will come more into play. But most of my clients are not going to sue the landlords. It's expensive, it takes time, and the dollar amount isn't warranted. If I sent someone to a litigation attorney, they probably want a $5,000 or $10,000 or $15,000 retainer check to try to save $5,000 or $10,000 or $15,000 worth of rent. So that's our problem, is it doesn't really make sense to sue The landlord's problem is they can't really do anything right now. You know, the Newsom thing came out and said that they can't, the California orders that they can't evict you for 60 days in a commercial or I think even residential lease. Most of the courts are closed in California except for certain events. So they can't even file unlawful detainer. And I'm not quite sure if they can do it electronic, but my research last night looked like they couldn't. And also it's cheaper for landlords to keep tenants. And this is really our leverage here. Landlords do not want to have an empty space, and they don't want to incur the cost to release the space. So they don't have to pay leasing commissions, rent commissions, negotiate tenant improvement allowances. So it's a two-sided problem. We're really not going to sue landlords. We really can't kick us out. It's cheaper for them to keep us. It's better for us because we spent so much money on our tenant improvements. We want to stay there. So what we really need to do is work it out. So the parties really need to work together and really understand that they need to resolve the problems because both parties are suffering severely during this time. So what are the options that we can try to accomplish here? Rent abatement, rent deferral, maybe using the security deposit. We make sure that we memorialize it in writing. And it's important when you're going through this to understand that there's another party out there that could potentially mucking up the works, and that's the landlord's lender. So if you have a landlord who's a mom and pop and they don't have any debt on the place, they have far more flexibility than a landlord that has a large amount of debt, because any modifications to the lease that impact the rent has to be approved by the landlord. So I think landlords are moving really fast right now. I've actually been very impressed with their speed and their attention to the matter, but at the same time, it can be slow. And it's slow because the landlords will maybe agree with us to do something, and then the landlords will have to go to their lender. And when they go to their lender, they have to get the lender's approval, which means everybody needs to work together. Landlord's lender, the landlord, and the tenant, we all have to work together to get through this very difficult time. So what am I seeing happening? So I've been negotiating leases now, rent reductions and deferrals since probably the middle of March, probably after, say, the 19th, it really got heavy. What I'm typically seeing is, and this is in no particular order, landlords will abate all the base rent, so no rent for a period of 1 to 3 months. Some landlords will take 50% off the base rent for 1 to 3 months. And what I'm seeing the most is the landlords will abate the rent for 1 to 3 months if the lease, well, I'm not seeing it the most, but if they're going to give you free rent, they're going to extend your lease for an equal period to the abatement period. So if they give you 3 months free rent now and your lease is 60 months, your lease is going to go to 63 months. The landlord's going to get it back. They're just going to get it back later. At the time you're negotiating that, the question should be, at what amount am I paying for the extra 3 months? Because there may be a CPI built in, some cost of living increase, or some fixed 3% or 4% increase. So the abated rent that you're foregoing having to pay for 3 months could be less expensive than what you're paying at the end of the lease. So it's something, if the landlord says, don't pay for 3 months, that your lease is going to be extended for 3 months, then you'd want to say, but I want to pay at the same rental rate at the abated rent. And the landlord may agree or not agree to that. Most landlords are going to say, no, you're going to pay it at whatever it is, because I gave you free rent and we're extending it 3 months, but it's worth the argument. Now, one of the things I'm typically seeing is the common area charges are not typically abated. So the landlord may say you don't pay the basic base rent, but you do have to pay the triple net charges. And that's because landlords still have to pay to keep the lights on, and they still have to pay, their taxes may be deferred, but they still, actually, it's worth mentioning at this point that common area charges are going up for most buildings, disproportionate to what we typically see because of COVID-19. So landlords are having to take extra measures to clean the buildings, to keep everything wiped down. And so there's this extra expense of using different things to keep COVID-19 from spreading around office buildings. So landlords are very careful to say, we're gonna agree to abate the rent, but we're not going to agree to abate the common area charges. So if your rent is $6,000 a month and let's say your rent is $4,000 a month and $2,000 a month for operating expenses, they're still going to ask for that $2,000 expenses because they're going to want to pay, their help to continue what they're doing there. And be aware that next year when we get our common area expense sheets, we're going to see the common area expenses went up disproportionately. And I'm not sure how they're going to handle that in the leases, because a lot of leases will say one-off charges would not affect the base rent. So if you have a new lease in the first year base rent, that those would be excluded going forward. But we'll see how landlords deal with that. That's just another wrinkle in the problem. Note on the bottom there, landlords typically require that there's sufficient term left on the lease. So if you are asking for a 3-month rent abatement and your lease ends in 6 months, they're not going to give it to you. They're just going to say, no, we don't need to do anything special for you, work it out. And so a lot of my clients, a few of my clients are in a situation now where we either need to exercise an option or enter into a new lease in order to get the landlords to give us some kind of a rent concession. And so that's a very complex conversation that you have to look at a lot of factors. Is it better to sell the practice? Is it better to close the practice? And there's a lot of issues that come in play there. Generally, it makes more sense to keep the lease in place and transfer the practice for the situations where it doesn't make sense. But landlords are just not going to throw free money at you if they think that your lease is going to end in a short period of time. So that's what I'm typically seeing in rent abatement. Your attorneys that you're working with may have negotiated different things, but both from a landlord and tenant side, this is typically where I'm at most of the time if I'm going to give some kind of abatement. But more likely what we're going to do is some kind of a deferred rent, and this is what the landlords are doing more than abatement. Landlords are not saying they're just going to let you not pay. So what I typically see, landlords are agreeing to defer the rent for a 1 to 3 month period. The deferred rent then is paid back over a 12-month period, and typically it's interest-free. So, let's say, for example, I gave you April, May, and June. I might just pick September as a random number and say, starting September for the next 12 months, you're going to pay back, that $9,000 abated rent that I gave you, $3,000 a month. You're going to pay that over equal payments over the next 12 months. And this is what I'm writing the most, and this is what I'm seeing the most. Again, the landlords are typically not deferring common area expenses for the same reasons. And landlords, again, are requiring that there's sufficient term in the lease to make sure that it makes sense for them to do it. What I'm finding particularly disappointing and frustrating is, and it may be that landlords councils out there are recommending this, but landlords are now wanting us to pay the deferred rent back sooner if we get some kind of free money from the government. And so this is an issue to be aware of when you're negotiating with the landlords, because they may come back to you and say, yeah, we'll give you deferred rent for 3 months, pay it back over 12 months interest free. You're going to pay CAM charges, but then if you get any money from PPP, we want it. And we can't agree to that. And we can't agree to that because the PPP language is very clear. 75% has to go to employee expenses. That remaining 25% is covering utilities and other expenses of operation. And so I just don't think I don't think the loan is well thought out on the PPP side. I don't think a lot of us are going to it's going to work really well for a lot of us. It may work. Hopefully I'm wrong. But the 2.5 times rent, again, even now as they're extending the time period, is problematic. And to have the landlords come and say, we got to pay the rent back sooner, I think is a huge issue. So when I'm on the tenant side, I push back really hard on this. I just think it's a very unreasonable, piggish position from the landlords. If I'm on the landlord side and the landlord wants to ask for this, again, I think that goodwill is more important than getting a sprinkle, a few dollars here and there. So I would be aware of this in your negotiations. And the other thing is landlords may require a personal guarantee. So if you were fortunate enough to sign a lease as a corporation, you're a corporate, you signed as the president of the corporation, and you didn't have to make a personal guarantee, landlords are using this as a leverage to try to get a personal guarantee. So they'll say, we'll give you the 3 months deferred rent, or we'll give you the 3 months abated rent, but then we want a guarantee. And I would say, and you can talk to your attorneys about this when you do this, but I would not ever agree to give a personal guarantee if I didn't have to. And if I successfully had already negotiated a lease without a personal guarantee, 3 months rent doesn't get me excited to sign up to be personally guaranteed going forward. So those are some of the issues we're seeing on deferred rent. Another option is to use the security deposit. So if the landlord says, no force majeure, no civil code 1511A2, 1511-2, no, we don't have any abatement, no, we don't agree that we're going to do deferment, no, we're not going to do anything, then I would ask the landlord if he could use the security deposit to pay my rent for the day, and then pay that at a deferred, at another date. So, if the landlord uses a security deposit, then maybe 6, 12, 18 months later, I'll replenish the deposit amount. If you happen to be one of those tenants where the landlord gouged you when you signed the lease and they wanted a 2, 3, 4, or 5 month security deposit, I think it's a good time to try to negotiate that away. So say to the landlord, hey, why don't you use 3 or 4 months of my security deposit, and then I'll repay up to maybe 1 month of the security deposit. So that's another way to try to come at this with landlords that are being recalcitrant. And again, there's no guarantee that the landlord's ever going to see it our way, but it certainly is another bullet in the gun to try to use. So steps to take, and we'll get to the point of some questions here. Everybody should review their lease carefully. If you don't understand it, or if you want to get some help, hire a good attorney that does office lease work to really comb through it and see if there's any chance that there's any terms in there that can help you. And like I said, it could be as simple as abatement language saying that you don't have to pay rent if you can't use the space. Most importantly, I'd say actively engage the landlord, start communicating with the landlord, try to understand the landlord situation, make sure the landlord understands your situation. I think I'd plan for and document some kind of a reasonable modification that works for both parties. So get together, communicate, and really behave yourselves. Again, remember, it's a symbiotic relationship. This is not a time for gamesmanship. You'll need the landlord's assistance later when you're renegotiating the lease for additional term, or if you're transferring the lease pursuant to a sale of the practice. I mean, the hardest part about a practice sale is getting the lease assignment done, and the landlords can certainly interfere with that process. So even if you're not contemplating selling now, a year from now, or 5 years from now, or even 10 years from now, if you have the same landlord, they'll tend to remember it. So as I put here, remember that they're probably not going to remember that you were being nice, but if you can fill in the blank in ALE, this will hurt you with your negotiation power in the future. So be polite, and then contact your insurance agents. I'm not going to get into the insurance, and maybe Jonathan can have an insurance person come in and talk about business interruption insurance. Certainly it's a requirement in your lease. The landlords are requiring business interruption insurance in your lease. It's a requirement, but most of the business interruption insurance is tied to some kind of a physical problem. Either physically you can't work, or physically the place isn't available because of a fire, flood, earthquake, whatever. You might be able to have a business interruption clause that has specific language for pandemics. It's rare. You might have some business interruption for civil interference, which this is clearly a civil interference. So I won't say definitively the business interruption doesn't work. So far, most of my clients have not had much success. They're calling up their insurance people and they're just simply saying it's not going to apply. But it's certainly something you should give some consideration to. Okay, so I haven't looked at any questions. So let's see if we can do that now. And thanks for being patient. Do we have the right to ask for? Yep.
Sorry, go ahead. I can read some questions for you. You can read them.
Okay.
First of all, I appreciate it so far. For someone who hasn't done Zoom, you should be a YouTuber. Your studio and your camera look absolutely perfect. So let's go ahead and get to some of these questions. If you guys do have questions, go ahead and put them in the Q&A panel. There's about 12 of them queued up right now, so we're going to go through all the questions. But please find that Q&A panel and put them in there. Go ahead, Lee.
So the first question is, do I have a right to ask for deferral? No, you have no legal right unless you have some of the provisions that we talked about in the lease, where you have a force majeure clause. Maybe under under Civil Code 1511, we could ask for something if we haven't drafted around it. Straight out saying you have a legal right, other than Civil Code Section 1511-2, the answer is probably no. But I think everybody should be asking for it. And I think when you ask for it, you'd want to have the idea that you can use a force majeure clause or Civil Code Section 1511-2 or impossibility or frustration or purpose, those types of things. So when I say the answer is you don't necessarily have a legal right per se, there's nothing statutorily that says that a pandemic allows you not to pay rent. From a contract perspective, there may be some language in the contract that allows us to ask for it. So what options do we not have? We don't have force majeure. I think that we answered that already. On my lease, it states that the lease should at all times follow state laws. That's a great question, and I should have raised that issue. So thank you for bringing that up, Dr. Fairmont. If the lease says that you need to follow state law, then that is something we would try to use as well. So we would use force majeure, Civil Code Section 1511-2, and we'd use a specific term of the lease, which says, and a lot of leases say this, that we have to be in full compliance of all the laws. So if the law says, and by the way, I don't know if government is the law, they didn't pass a law, but certainly we can make an argument that government rules and regulations are prohibiting us because they're saying we can't use our facility. So that's certainly something that I would address in communicating with the landlords. If there was a clause on the lease that landlord did not do, would that nullify the lease? Or is there a penalty for the landlord? In my case, there was a right of first refusal, which the landlord broke when leased the space next to me without my knowledge. Okay, so this is really the flip side. So first off, if landlords are in breach of the lease, or well, a lot of leases have a waiver provision. So in the back of the lease, it'll say that landlord's not waiving its right against a breach to you unless it specifically waives its rights. And in a lot of leases doesn't have the reciprocal language that says the tenant's not waiving the right to a breach. So it's important when you're negotiating leases to try to get a mutual waiver provision. Secondarily, if the landlord has a duty to have the right of give you the right of first refusal, they should honor that. Now they may come back and say because of COVID-19 that they're going to use force majeure, or they're going to use any of the other things that I addressed to allow them to break having to comply with the terms of the lease. Like I said, exclusivity, right of first refusal is a perfect example. I certainly would challenge it. I think we would go back and let them know that they're in breach of the lease, and I'd let them make the arguments. We don't make the arguments for them, so we don't give them the bullet to shoot us with. I'd make an argument that they're in breach of the lease, and I'd point that out. And if they don't acknowledge it, then I'd hire a litigation attorney to really comb into the lease and really look at the issues and see if there's any claim you can make there. It says if we're getting our PPP loan, isn't it in our best interest to pay the rent for 8 weeks period versus deferring the rent since those payments will be forgiven? That is an accountant question. I would say that I don't know that I have the answer on how that impacts your PPP. I think my position at this point is most of my clients don't have the PPP money. So I don't think I have a single client who's called me up and said they received the EIDL money or the PPP money, and we're now in the mid-April. So some of my clients have, in fact, I wrote a letter the other day asking for April, May, and June. I know they've applied for PPP money, but it's just that they haven't seen it. So that's a good question for your accountant and how that would impact your PPP. If it's going to affect your ability and limit what you can defer, then maybe it doesn't make sense to do it. But certainly right now, if you haven't paid rent for April, or if they're giving you abatement for maybe April and May, then I still think it'd be to your advantage. Do I need an attorney to write the landlord that there's a force majeure clause in my lease if my landlord has refused to defer, debate, or abate my rent? I mean, if the landlord's recalcitrant, hiring an attorney may not help anymore. But I generally think having an attorney write the letter and articulate not only force majeure, but Civil Code Section 1511(2) and maybe some of the other common law defenses. Yeah, I would certainly think having an attorney write the letter. But if the landlord just can't do it, they just don't have enough money to do it, then they're going to fight that. And then you will be forced into a situation where you have to sue them. And then we're going to have to decide, does it make sense financially and time-wise to go through a litigation process? So having an attorney write the letter may be useful, maybe are more articulate in explaining some of the other issues at play, but may not move the landlord one bit, but certainly worth a try. Question, I have an office under construction. I have a loan through 2 lenders. One is a bank. The second is through an interim paying interest in the loan until construction is completed. When completed, SBA will take over the loan. I've asked for a deferment. I was denied. I made them aware of my situation closed by Fed State. What are my rights? Well, you raise an issue about building out and constructing an office during this difficult time. Landlords can use force majeure to potentially not pay tenant improvement money. That could be an argument with your lender. Landlords can also potentially interfere with your construction because they're not making the building open. So they may say, you can't bring in workers during this difficult time. So your construction periods may be interfered with. You may also have a problem with getting permits and getting the city to sign off because the cities are closed. So if you can't get a reasonable review of the permit to get approved, or if you can't get a reasonable inspection to get things signed off, that is going to interfere with your ability to timely get the construction completed. So I think it's reasonable to write a letter to the banks. And I think most banks are giving some deferments. I've been reading mortgage deferral documents on a daily basis, and they're pushing the payments out 2 or 3 months, and then their interest is accumulating during that time. Interest is still being charged, but they are deferring it. But in your discussion with the lender, I would push back and say it's impossible for me to perform and get this construction completed because I can't get my permit. I can't get the inspection because the city's closed. The landlord's not doing this. The landlord's not doing that. I think it's a reasonable position to take that this is interfering with your ability. And I think most lenders are agreeing to do that. If this is recorded, where do I get to watch it again? I have no idea. Hi, Marcella. How are you? You can call Jonathan. I don't know if it's recorded, so you can answer that.
Yeah, Lee, with your permission, I might make it available to people. What I'll do is I'll edit it, and then I'll send you a copy. And then if you approve it, we'll go ahead and send it out.
Yeah, I'll just go ahead and approve that. That's fine. Are your PDFs available after this webinar? Yeah, here's my email address. And what I'm going to tell my assistant Jill to do is convert the PowerPoint to a outline, and then we'll make those outlines available for anybody that sends in an email. So send Jill an email and request an outline, and I'll let her know to send it out. My landlord offered a 5% discount on my rent, but still wants to be paid. My rent is $8,000 a month, so is any advice to negotiate with the landlord? I still have another year and a few months on my current lease and have 3 5-year options to renew. Yeah, I'd say, if you're trying to get more from the landlord might want to get more from you. So if you're going to definitively stay in the space, and that's a difficult question now because we don't know if we're going to be able to open up our offices and we're going to get back to speed. But I'm going to assume that you want to stay in your space. $8,000 a month is probably a nice space. And you've got some nice TIs in there, and 3 5-year options. I'm guessing you want to work for a while. So I think it's in the best interest to keep your lease in place. I think if you go back to the landlord and say, I'd like to maybe consider exercising my option now, putting the other 5 years in place, but I'd like to get some more deferment. And then of course, take care of your lease, take a look at your lease and see what terms in your lease that potentially help you. Some of the things that I cover in my lecture, that would be helpful. Been on a month-to-month lease for 25 years and asked for an abatement, but have not gotten apply. Can I be evicted in 30 days? Well, most people, depending on where you're at, it's 60 days now. You're on a month-to-month lease. I told you need to be aware that the landlord could charge you a holdover rent if that's in your lease. Landlords, if I'm landlord's rep and you're asking me for a free anything, I'm not giving it to you. You want to sign up for a a 5-year lease, I get more interested. But people that are calling me up and asking for free rent when they have on month-to-month leases, the answer is almost always no. In fact, if somebody is asking me for free rent and there's 6 months left on the lease, the answer is no. When I'm on the tenant side, I'm happy to ask for it. On the landlord side, I'm unlikely to provide it. I'm unlikely to advise my clients to accept it, and they're unlikely to accept it. Let's say I've been offered a deferral for May only at this time, but they are requiring April to be paid, which I've not been able to pay. Again, I'd push back and try to get April, May, and even June paid, because we still don't know if we're going to open in June. And right now, know that you're in default because you didn't pay April rent. And if you didn't pay April rent, they can charge you a late fee, and they can also put you in default. So I'd be very careful with that. If they'll agree to May, June, and July, maybe, then you can go back and try to find a way to pay April. But I try to take a look at the term on the lease and how much longer. You have 5 years on the lease. We're going to be working together for a while and find a way to reasonably communicate. Some landlords are just impossible, but certainly I would be asking for more, and I would use some of the issues that I raised in this presentation as your ammunition. Thank you, Lee. A more general question. I'm on my 4th year of a 5-year lease. I may buy the building space in 2 to 3 years. Should I go month to month on the lease or sign a more long-term lease? Obviously, if you think you want to be there in the long term, you should sign a lease. I never recommend not having a lease. If you take the long game and you look at this, you have to really look at a lot of things that impact you over a period of time. And one of the things that I deal with all the time is death and disability. So I have 4 to 5 doctors a month that are disabled. I have 1 or 2 doctors a month that die. And so if you want a month-to-month lease and you happen to not have a lease, it's going to be very difficult for your heirs to sell the practice. And the new tenant's going to have to come in and negotiate the lease. And sometimes they can negotiate around you. So they come in and say they want to buy your practice, and they start talking to the landlord. The next thing you know, they got a direct lease with the landlord, and now you're having to move to another location, which costs hundreds of thousands of dollars, to build out. So my advice is always have a lease. I don't, and if you because of death, disability, but just for long-term business strategy, it makes sense. If you think that you want to buy it sooner, then when you negotiate, maybe go on a 2-year lease with a 3-year option. So if you don't have to be just 1 year. They don't have to be. The lease doesn't have to be renewed in 5-year terms, but you certainly can approach it with a 2-year lease or a 3-year lease with a 5-year option. But in my advice, I would always have the lease in place. Again, get your primary attorney that you've been working with to discuss this issue, but I think that's an important thing to consider. Hi, the building is being managed by a company that does not respond much to my emails. Is it better that I request to contact the landlord directly? Yeah, that's a tough one. I said, most of the landlords have been very responsive. Some of them are difficult, and I'm in some negotiations now where we're just having very poor responses with landlords reps. Typically, if you go around the landlord rep, it really comes back to hurt you. They really make everything more difficult in the future. So if you can find a way to get in front of that person, by maybe sending a registered letter or some kind of other communication. I'm certainly not going to go knock on their door, but calling them up. And then you can request, can I talk to the landlord if you're not available? We understand this is a difficult time. I mean, try to show some compassion. I know things are tough, maybe, because people are working from home, people are raising their children. I talked to somebody yesterday who's a dentist who's teaching fifth grade to his children. I mean, everybody's so out of sync right now. So just remember to be compassionate, and this person maybe is having other events going on in their life. And suggest, though, I understand this is a busy time. People are all trying to contact you, you have other things going, but it's imperative that I speak to you as soon as possible. If not, is there somebody else that I can speak to? And I know we had a situation a few days ago where we just couldn't get a hold of the person. And finally they responded and said, you're calling the wrong person, which is great. He could have told us that 10 times already, but just clearly not responding to his emails. So I would just stay persistent on it. I'm a tenant. My question is my right to ask the landlord to modify the lease now, such as adding, okay, we can address that. If I have a verbal deferment from the landlord, should I request it in writing? A verbal, I would want it in writing. Absolutely. I mean, at least an email, but I'd want it in writing because I wouldn't want the landlord to come back and put you a default and maybe kick you out of the space. So if you haven't paid your rent, the landlord could give you a 3-day quit notice, give you a notice to evict, and maybe give the space to somebody else that wants to take it. So absolutely get it in writing. Okay, thank you. Let's see, I plan to buy a commercial condo. The listing agent tells me the seller doesn't release information about triple net. Well, that's just ridiculous. You should be able, whether you're renting or buying, get all the information that's necessary to make a cogent business decision. And a typical seller documents would require that you get all the information about all the tenants in the building, all the triple net costs, permits, everything. So I'm not sure why that agent's taking that position. Maybe because you're not in escrow yet, but when you get an escrow, there in your definitive sales agreement, there should be some language in there. If there's not, it should be added that the seller is going to provide you with certain information so you can make that important business decision. And one of the things will be all the information about the lease, because you have to know what the lease rates are, and you have to know what the triple net costs are. So I think we made it through. Let's see, maybe not. Let's see.
There was a correction to a question, a typo, I guess.
Okay, so I think that covers it. I appreciate it. Look, 12:07, so this might be the first time that I've been even reasonably close to finishing on time. So I want to thank you all for attending. I understand this is a very frustrating time and a very frustrating topic. And I know that the problem is we lack leverage in our negotiation with the landlords, and that makes it difficult. We've spent hundreds and hundreds of thousands of dollars in our leasehold improvements. All the goodwill, a lot of the goodwill is tied up in the name and the address, but certainly in the address and the location of the practice. And so it's important for us to stay there and not having to relocate to a new space. So, we feel vulnerable, but at the same time, we're not asking the landlords to do anything that's unreasonable. Deferring the rent so we can stay as a tenant in the place makes sense. As I said, it's cheaper to keep us. And I don't mind you using that phrasing. It's cheaper for you to keep me, landlord. Why would you want to have a vacant space? Why would you have to go out and pay a broker commission? Why would you give somebody else free rent that you don't know? Why would you give tenant improvements to somebody you don't know? Why don't you keep me here and help me, and let's help each other get through this difficult time? So I think that's the general message, is be reasonable. Yelling and screaming and kicking doesn't typically get us anywhere, and it hurts us in the long run. So I think, did we get another question? I think that's all of it. So thank everybody for tuning in. And thank you, Jonathan, for putting this on. And I want to tell you guys that preparing for this was a little bit painful, because I had to go back and remember what I learned in law school and go back and look at contract books and restatements of law. And I say that because I want to tell you that any information I provided you, a litigation attorney may just simply say, no, that won't work. And that's possible. The landlord may, an attorney may say that. But if you get into litigation, the attorneys are going to look at all of these issues. They're going to do a very deep dive. That's why it's so expensive. They're going to try to uncover every law that helps us. They're going to try to cover every case that helps us, and really trying to find a solution to remedy our problem. Unfortunately, most of you nearly all of you are not going to get to that point because you're only going to have 2 or 3 months where you're not paying rent. So you may not have to ever address those issues, but hopefully what I prepared will help you in responding to the landlords. And if the landlords don't respond positively, they may never. But certainly, if you have legal counsel that you worked with in the past, have them, write you a letter and see if they can get anywhere with it. You can talk to the broker you work with to see if he's seen anything that's happened. But I will tell you this is that landlords, because I do landlord work and I read the landlord side of it, they're encouraging the landlords are saying that they need to be consistent. So landlords are trying to work through this problem. They're trying to figure out a way to continue to pay their bills, but they're doing it in a very consistent, orderly manner. So if they're doing it for one tenant in the building, they're probably going to do it for all of them. And that's because they have to go to their lender to get an answer. So they don't want to have to go to the lender every single time and incur legal expenses to get the landlord to approve a different amendment or different amendment. So, if the bigger the building is, the more tenants they have, more likely the landlord's going to say, this is our position. And I got that very clearly the other day. Someone said, we'll defer it 30 days, 12 months, no interest, but we want to pay back any money you get from PPP and the IDL, and we're not going to let you abate common area expenses. So from a landlord perspective, it's going to be a consistent approach. And so if the landlord's saying no, ask again, and then try to get somebody to read your lease and help you maybe write a letter to see if there's a way to persuade the landlord to do it. And I got to tell you, some of the mom and pops, they don't know what their leases say. And maybe they don't have the financial wherewithal to give you the abatement, but they really don't know what their leases say. And they buy stuff on the internet, and they may buy something called an AIR form or CAR form, and they don't see force majeure, and they think that's the end of the conversation. But as you see through the presentation, there may be other arguments you can make. And so have someone write a well thought out letter for you and see if they can help you out. And you have legal counsel you've been working with, and they can, they understand your position. Maybe they help you negotiate the lease, and maybe they can help you write a letter to help you get through this. So that's it. Thank you very much. Enjoy the rest of your day.
Lee, thank you so much. We had close to 200 people on the call, and there's a lot of people saying thank you in the chat box. On behalf of those people that joined the call, I can't thank you enough for taking the time for us. We might ask you to come back next week or in a couple of weeks for either another topic or to revisit this as this situation develops. Anyone who needs to contact Lee, his information should still be on your screen. If you have any questions that weren't answered, you can send an email to Lee or send an email to me, and we'll go over it. Once again, thanks everyone for coming on. Please stay safe, stay healthy, enjoy the time with your family, and please feel free to refer anyone else to this call that might enjoy it. We're getting more and more people each day. Again, I just want to bring you as much prevalent information as I can, and hope you're enjoying it. Lee, thank you so much for your time.
Thank you, Jonathan. Take care, everybody.
Thank you.